we're ready to get started if you are.
Yes, good morning and welcome to today's webinar, which is our very first Coffee with the Court virtual program. We are thrilled to have the following judges present to you today: the Honorable Jane Doyle, U.S. District Court for the Northern District of Texas; the Honorable Ada Brown, U.S. District Court for the Northern District of Texas; the Honorable Irma Ramirez, U.S. Magistrate Judge for the Northern District of Texas; the Honorable David Horan, U.S. Magistrate Judge for the Northern District of Texas; and the Honorable Rebecca Rutherford, U.S. Magistrate Judge for the Northern District of Texas. Should you have any questions during today's program, feel free to use the Q&A function located in the bottom center of your screen. We will try to answer some questions at the conclusion of the webinar. In order to receive CLE credit, you must self-report to the State Bar of Texas. If you have a pen handy, I will provide the course number to you. The course number is 174-080-332, and it's been approved for 1 hour of CLE credit. We will provide the course number again at the conclusion of the program. I will now turn it over to our moderator, Sabah Syed, a senior associate at Bell Nunley & Martin, LLP, to begin today's program.
Thanks, Cherie. So this first question is for Judge Ramirez and Judge Horan. Discovery disputes tend to be the easiest way for young litigators to get federal court experience. Do you have any practice tips on
so
how
sorry.
to
Do you want to introduce us first? Introduce us real quick. Introduce us real. Oh yeah, you did. You did. Never mind. I'm so sorry. Forget it.
That sounds good. And to be clear, I'm directing this question to Magistrate Judge Ramirez and Magistrate Judge Horan. And I'll be directing specific questions to certain judges in the interest of time. So for this first question, Judge Ramirez and Judge Horan, do you have any practice pointers for young litigators on how to effectively handle discovery disputes, especially while many of us are under shelter-in-place orders? And we can start with Judge Ramirez.
All right, sure. Well, my first tip is confer. Absolutely confer. It's required by the local rules, it's required by the federal rules, and it's going to be required by the person hearing your dispute. So it's very important that you show the court that you have attempted to resolve the dispute before you come to court. Be sure that you have a basis. Over the past 17 years, I've seen a lot of discovery disputes that would not have been in court if the attorneys involved had done a little bit of research first and looked at the case law. And there's a tremendous amount of case law out there on just about any issue. And my colleague, Judge Horan, has written a lot of opinions on many discovery disputes, and I appreciate that very much, Judge Horan, because I can just cite and say, have you read Judge Horan's opinion in X? So do some research. Be sure that you're right, because you don't want to come into court with a discovery dispute that is not a valid dispute under the existing case law. Be reasonable. We are all trying to make our way through this new situation here with the COVID pandemic, and we're having to be a little creative. One of the issues that came up in a recent Zoom conference with Judge Hoffman was depositions. You know, we've all taken depositions. I know I certainly have taken enough depositions in my career that I understand why you want to have the witness there in person. But that may not be the case here. We have social distancing, we have the inability to fly and travel, and we may have to be creative. So people have to be reasonable and have to be patient. And we're trying to figure this out. So those are the 4 points that I would like to make on discovery.
Well, I agree with everything Judge Ramirez said, I guess, other than complimenting my decision. So I appreciate that. But leave that to others or whatever anyone thinks. But I think that I do think those are the key points. I guess I would also say, I mean, particularly regarding some of the disruption and legal practice, and obviously everyone's daily lives based on the COVID-19 pandemic. I mean, to the extent that that is affecting your ability to do discovery or certain things, or to meet certain deadlines, I think part, I think this is always good advice, but particularly this time, just be straightforward about that and up front, both first with your opposing counsel and making sure that you all try and be as reasonable and get things done as efficiently and effectively as you can under the circumstances in which you or your clients find yourselves at this point. But then if you do have to bring that to the court, I mean, just yeah, I mean, again, this is just generally good advice, but I think just be very upfront about that and very straightforward about what's really going on, what you really need, what's really possible. But I do think is sort of in terms of a don't to pick up where Judge Ramirez left off. I mean, I think, for instance, there's always been a rule permitting remote depositions on the agreements of the parties, by stipulation of the parties, or on an order of the court by a motion filed by one of the parties. Obviously, each of us, if we're faced with that issue, is going to look at it on a case-by-case basis, but we're not entirely sure how long this is all going to go on. It may not be reasonable to sort of, for months at a time, take the position that discovery is just going to stop in your case, when with creativity and using technology, even if it's not ideal in the way that everyone would like it to happen, discovery, particularly deposition discovery, could go on. So I would, again, just to pick up on that point, I think the one I don't is to, particularly for some extended period of time, perhaps going forward, just act like nothing can happen, or it's completely impossible for you to accomplish anything in discovery. That doesn't seem like a realistic and reasonable way to go going forward, even with us understanding the limitations that all of our sort of global circumstances at this point present.
Thank you for the answer, Judge Moran and Judge Ramirez. To follow up on that, COVID has changed everything in terms of the landscape of litigating in federal court. Our next question is for Judge Boyle and Judge Rutherford. As attorneys shift to a virtual platform, do you have a preferred platform to conduct hearings or court proceedings? And if you do have a preferred platform such as Zoom or telephone conferences, why do you like that platform?
I want to defer to Judge Rutherford first on this, but I also wanted to say in relation to what Judge Ramirez and Judge Horan were saying, that discovery, nothing should stop. Everything should presume to go forward unless we tell you otherwise, or you motion the court for a continuance or something like that. Nothing should stop automatically during this COVID-19 crisis. And Judge Rutherford, you've done this probably more than I have, so why don't you talk about your platforms first?
Well, thank you. Good morning, everyone. I hope you're enjoying your coffee with the court. My preferred platform actually is still the telephone conference. I find that while it's great to be able to see people's faces, not everyone has the same electronic capability. We have a disparity in party resources sometimes. Not all law firms are using the same preferred platform. Zoom has sort of come on quickly and taken over, and we're using it today. And like I said, I really enjoy seeing people's faces. But the telephone, everyone knows how to use. I don't have to provide any special instructions to someone to dial a telephone. For our courtroom, the federal magistrate judges, we record most of our proceedings through FTR, for the record product, and the telephone hooks up to that very well. It makes a clear record for the court reporter who would transcribe it later on. In the magistrate judges' courtrooms, we do not have a court reporter live with us unless one is specifically requested. So for the most part, we are recording, and I think the integrity of the record is better with the telephone conference. So when we have official things that we're putting on the record, hearings especially, I still prefer to do those by telephone.
Yeah, I've done them telephonically too, and I don't know why I have, but I think that it is much easier. Like Judge Rutherford said, I've had TRO hearings and things like that on telephones I haven't done any Zoom conferences yet, none at all. But I'm going to do a sentencing tomorrow, and that's criminal. In criminal cases, it's much different. We're doing those, I think they're doing them in the courtroom for the most part, maybe not. I am doing them all in the on video conferencing, and we'll see how that goes. I'm doing my first one tomorrow, but I prefer the telephone too. Right now, if it goes further, much further, maybe we'll go with Zoom. But I can't see it in the foreseeable future.
Thank you, Judge Boyle, Judge Rutherford. To follow up on the discussion with Judge Horan and Judge Ramirez on conferring, Judge Brown and Judge Ramirez, what expectations of professionalism do you have for young advocates? And do you have heightened expectations of professionalism as a result of COVID-19?
Judge Ramirez, I invite you to start the discussion.
Thank you, Judge Brown. I think judges are always going to expect lawyers to be professional. We are professionals, and especially when you are in court, whether it's an in-person hearing, a virtual hearing, a telephonic conference, we're always going to expect professionalism from the attorneys. We understand that tensions run high. People feel very passionately and zealously about their cases, and sometimes their clients push them to be very zealous in representation. But at the end of the day, an attorney is an officer of the court, and you are putting your reputation on the line every time that you step into the courtroom, whether it's a phone conference or an actual courtroom. And we're going to remember you. We won't necessarily know that it's your client asking you to zealously advocate. We're going to remember how professional you were. And that's going to carry through not just that case, but any subsequent case that you appear in front of us. And judges talk. When people are especially professional and when they're especially not, it is something that it gets known. It doesn't just stay in that courtroom or in that proceeding. Do we expect heightened professionalism during COVID? Maybe, but I like to think that if you're always a professional, then you're not going to have to change anything when there is an emergency or a situation that you've not been in before, because you're going to know how to conduct yourself, and it's always going to be with the utmost level of professionalism.
Just to piggyback on that, here's an example of how what Judge Ramirez said is true. This has probably been 15 years ago. When I was a trial judge many years ago, before I was a federal trial judge, when I was a state trial judge, I had a very senior attorney cite a case to me during a hearing. And based on that case, I made a ruling and suppressed some evidence. Well, I found out shortly thereafter that it was bad law. And so I had to go back and undo my ruling. And you will be surprised as you practice in Dallas how small the legal community is. Every time I see that man walk into a room, I can't help but think, that's the lawyer that gave me the bad law. And that's been 15 years ago. So professionalism is so important. There is no one case worth winning, worth blowing your whole reputation. And we do talk. We talk about really good lawyers. We talk about really bad lawyers. If you think of it in terms of reality TV, which I know is very popular, you all are our show and we are yours. Just as you talk about judges whom you like and appreciate, and the ones who you think need improvement, we do just the same.
And on top of all that, I'd like to say about conferring, it is, you can have the worst dispute in the world. The best thing you can do is, before you go to court, confer with the other side. Try to get some common points that you can agree upon and try to go to the court with solutions. That's so much better than throwing the dispute out there and not talking, because then you're sort of stuck with random thoughts about what the judge might do. And so if you go prepared, you've talked to the side as much as you can, and you come with solutions, it's much better. So both professionally and for purposes of winning, it's much better.
That's a powerful reminder on maintaining professionalism while we are operating under a very unique situation. And I think the judges make a great point that especially it's always important to be professional and a good advocate will be professional under this circumstance or any other circumstance. With COVID-19, obviously hearings and oral advocacy will be impacted, but we are curious about how written advocacy will be impacted, if at all. And in addition to that, is there going to be a preference on written advocacy, and how can we make our briefs better, our writing better to the court? So this question is for Judge Horan, Judge Rutherford, and Judge Brown. Do you have any advice for young attorneys on how to effectively communicate in writing to the court, or in other words, write more persuasively? And Judge Horan, we can start with you.
Oh, sure. Let me pick up your last question first. In contrast to the rules and just really the whole structure of our state courts down the road, everything is presumptively handled on papers in federal court. I mean, in civil side, our local rules make clear that an oral argument or hearing will only be held if the presiding judge elects to hold it on request of the parties or otherwise. So in that sense, these circumstances in which we find ourselves with the COVID-19 pandemic haven't changed that much, but I think if anything makes it all the more important that you expect that a lot of things are going to be resolved. Most things are going to be resolved on paper. And I don't think that's really any different than it normally is. A lot of us like to have oral arguments on motions. Obviously, we have hearings when we need to have hearings, whether it's an evidentiary hearing or otherwise. I think everyone on this call likes seeing lawyers in court when we have the opportunity, but obviously there's some limitations on that right now. So all the more so, you really have to expect that if you're presenting an issue to the court by way of a motion, that it's very likely going to be decided on the papers. Again, I think written advocacy and expecting that perhaps the papers are going to be the main show in resolving an issue is always the default you should have in federal court, and certainly in our court. And so then in terms of what's effective there, it's the things that normally are. I mean, being straight, well-organized briefing that lays out the issues clearly, is organized with headings, and it makes clear exactly what it is that's the issue and exactly what it is that you want, and does so with as short and crisp of writing as you can manage, which we always say we understand is harder than writing long, right? I mean, right? The irony, of course, is that it takes a long time to write something short because that involves a lot of discipline and editing it down. And there can be limitations on that. I mean, the time limitations and other limitations. We also understand that it doesn't often make sense to have the perfect be the enemy of the good. But to get something really good in terms of writing does take some time, and the shorter the better. I'll say. Shorter section, shorter paragraphs, shorter sentences, shorter words is always the most effective in terms of what really works. But I think what's really critical always, and we all of us, the magistrate judges, bankruptcy judges, district judges in our court are moving a lot of paper, and we are looking at a lot of motions and have a lot to resolve at all times, and now is no different. So the more we can pick up the briefs and quickly understand what's at issue and find it well organized as to where we need to look in the briefs and the response brief and the reply as to each of the matters that are at issue. And again, if the motion very clearly lays out what precisely it is you want and are asking the court to rule, that's really when we see the most effective written advocacy, and it's most beneficial to the court in terms of being able to get to the substance of what's at issue and make the decision that we need to make.
Thank you, Judge.
I'll build on that with maybe some sort of nuts and bolts tips that I think young lawyers may actually be responsible for. I think more and more judges are moving towards reading everything that's submitted on their computer screen. I think if one of the things that may be the result of what we're dealing with right now in terms of the COVID pandemic is that judges are working at home. They don't necessarily are not able to print the entire record or the 50-page brief. So I think more and more of what you are writing is being consumed in an electronic format. So I think it is important to pay attention to how your brief looks and works on screen. There are easy tips to pick up all over the internet about what fonts are easy to read on the computer screen. I think it's important not to try to skirt the local rules and use font that's a little bit smaller. I think white space is important. I think table of contents are important. If you have the capability to hyperlink your table of contents directly to the section of your brief, that is a very helpful tool to be able to implement. I think it is important that you do not overburden your exhibits. If you have a particular section of a deposition that you need to cite for your summary judgment record, cite those 2 or 3 pages. Don't submit the 200-page exhibit. It makes it very cumbersome for the court to sort through. And I think a selective presentation of your evidence makes it look like you've thought more carefully about what it is you're presenting the court, as opposed to just taking a shortcut and attaching the entire deposition. On the subject of exhibits and writing and communicating effectively, I would also caution lawyers, particularly young lawyers who might be charged with dealing with a particularly difficult opposing litigant, like a pro se litigant, to realize that everything you put in writing has the potential to become Exhibit A in a motion for sanctions or a motion for attorney's fees. So especially when we're under pressure and stress, resist the temptation to be snarky in your emails to opposing counsel. Try to always take a deep breath and maybe step away from your computer screen before you press send, because you should anticipate that any email that you send could be Exhibit A. So just censure yourselves. That would be my suggestion.
Thank you, Judge Rutherford. Judge Brown, did you want to weigh in as well?
Sure. The only tip I can think of that might be helpful to add to that is when you are writing, you want the court to rely on your briefing or your motion to give them the whole story. There's nothing more frustrating as a judge. I mean, just think about briefing or your motion as a book. Everyone wants to know the beginning, middle, and end of the story. And so even if you have facts that are not the greatest for you, I think a good litigator should put those facts in and put your spin on them. Tell me why that's not as damaging as the other side is going to say it's going to be. I can't tell you how often I'll pick up a motion or a brief and find out a critical fact when I pick up your opponent's brief. And that's really a missed opportunity for you to tell me first and kind of take the sting out of it. Every case has facts that you're not delighted with, but put the facts in your motion or in your brief and tell the whole story, because it really kind of goes to your credibility. And take the opportunity to give it your spin. If the contract wasn't signed and this is a breach of contract case, don't let me find that out when I read opposing counsel's brief. You tell me it wasn't signed and tell me why it wasn't. Maybe you have a client who isn't literate. Maybe you have a client who does handshake deals and that's the custom. I mean, there's all kinds of reasons why that you can take the sting out of that might be pertinent, but don't skip the story because you think it's going to hurt you, because I guarantee the job of the other side is to bring up just those facts without fluffing it up and without telling whatever story you would. So you want the judge to read your brief and get the whole story from it. It's not good for you when I have to go to the other side to find out what happened in this case.
And just very basically, I just wanted to say, add one thing, no matter what else you're doing, make sure that you start whatever you're writing with the elements of proof. The elements of proof are whatever, it's a TRO or whatever, you've got to build on the elements of proof, and that's where you start, because that's what we look at. And so if you think about what we look at what do you have to prove and how have you done that, and keep it tendered to that.
Saba, can I add something as well? because it is in federal court, as my colleagues have pointed out, it really is all about the writing. So to sort of jump off on something that Judge Horan said, that it takes time to make something short. When you don't take the time to do that for us, you're shifting that burden to us to try and sort through and figure it out in a short, succinct way. So when you help us, that makes it easier for us to understand and respond to your issue. And I also wanted to follow up on something that Judge Rutherford said about exhibits. Your appendix is so important, especially when we're looking at everything on the computer and we're looking at your appendices on the computer. And this has been an issue for a while. CMECF has the capability to allow you to break up exhibits in the same manner as with a paper appendix with tabs A, B, and C. I have looked at so many appendices that are just groups of documents, 191 pages in the first attachment and 162 pages in the second attachment and 203 pages in the third attachment. And then the brief cites me to page 432. Now I'm having to do math. Okay, and guess which one it's in and try and find it. And so that slows me down and it makes it harder. So that's something that you can really help us with, is break up your exhibits by A, B, and C, 1, 2, and 3, but in a way that helps us get to them more quickly.
Doesn't it violate the local rules, Irma? I mean, to do that?
Well, no, the local rules just say you have to have a separate appendix and it has to be numbered. But these are the little things that make it easier for us, that really do help us, and it's not in a local rule. And then the last tip I have is something that I talk with my law clerks about. Have somebody who doesn't know anything about your case, read your final draft and see if they understand what the issues are and what it is that you're trying to convey. Because when you're in the middle of it and you've done so much work and you know all about it, but you put it down on paper, you're assuming that we know what you know. And the only thing I know is what you put down on paper. And so sometimes those dots, I talk about connecting the dots with my clerks all the time. Sometimes the dots aren't connected. And if you're missing some dots, I can't draw the lines to see the picture. So if you have somebody just one last proof for you, that can be so helpful, because they can point out where things are missing to help you better explain and provide more context for your issue so that you can get the result that you want.
If I could add one thing to pick up on what Judge Ramirez just said, you should always have somebody else read your final draft and make, in fact, a final proof, including for substance and understanding, is exactly like Judge Ramirez said. If for some reason you can't do that, or on top of that, another tip, which probably everyone on this meeting has heard, but you can also just read your draft once out loud to yourself. I mean, reading out loud is one of the best ways to catch missing words and typos, and also just to, a lot of times something will look okay on paper. Look, and I mean, anybody who's read anything I've ever written, I don't shy away from long sentences. It's kind of the way I'm wired. But something can look fine on paper, and if you read it out loud and you yourself have trouble following it, it's a good idea to break that sentence up or rewrite it.
And that's
that can be one of the best ways to. It's one of the best ways to figure it out. So.
Well, I have some follow-up questions on this, because it's clearly an important topic to the judges, and clearly writing well is an important part of practicing in the pre-COVID era, post-COVID era. But for Judge Rutherford, I wanted to pick up on something that you had mentioned regarding reviewing briefs, especially for those judges who are viewing briefs from their home. Does the court have a different practice with respect to courtesy copies of sending handwritten briefs and binders as a result of COVID, or should we expect to just send electronic copies of our documents?
That's an excellent question. The courtesy copy requirement varies from judge to judge, and I think just about every judge in the Northern District has a link on their court website which specifies whether they require courtesy copies or not. I don't know that any judge has changed their practice in view of COVID with respect to those requirements, but I would anticipate, so if the judge requires courtesy copies, you should proceed with that requirement unless you're instructed otherwise. I would anticipate, however, that your briefing is being consumed online as long as the courts are in a remote function.
And typically we would mail these courtesy copies to the courthouse, even if the judges are working from home. So it sounds like the attorney should just continue that practice unless instructed otherwise by the court clerk or the court.
Yes, the court will arrange for home delivery if that's required. I don't think any attorney should take it upon themselves to figure out where the judge lives and to deliver documents to their home.
Right.
That would not be advised.
That's right.
That might get you to know a different part of our court family.
Well, by that same token, kind of on the flip side of the situation, Judge Boyle and Judge Ramirez, could you weigh in on practice points for effective oral advocacy, especially during the pandemic era?
Well, let me just say that first off, I think effective oral advocacy always starts with making sure you're aware of the format. You want to make sure that you're aware of, is it an evidentiary hearing or is it not? And talk to the other side and make sure you know what they're going to present. So, you know, are they going to have exhibits? Are they going to have overheads? Are they going to have go-bys or something? And just know that so you can prepare, so you're both going to court with the same idea of what the format is. And I can't tell you how many times I've had it different than that, where one lawyer will come with a bunch of exhibits or overheads or something, and the other side has nothing, and they complain because they didn't know, and all they had to do was call ahead of time and try to find out. If the other side won't tell you, well, that's a problem. But you need to try to control the format. And then once you get to court, you want to be as cool and calm as possible. It doesn't matter what, you know, everybody is together in this court because there's a dispute going on. So you're upset a little bit. I mean, everybody's just not happy. You know, you go in there, they're a little upset or they're a lot upset. And so I think it's important to remember that you are there as the advocate for your client. You are there to take these slings and arrows calmly and objectively so you can tell your client what you think they should do. So make sure you keep your cool. And not only that, but it affects the way you look. I mean, you don't look as intelligent when you are mad. You just don't. Now, there's a thing about righteously indignant. That's different. That's fine. In certain cases, that's fine. But just keep it. I mean, I always like the lawyers who say, you know, I could address that, Your Honor, all the anger, but I'd like to stick with the facts. And these are the facts, and this is what we want, and this is what this all is all about. And that's so critical, whether you're a young lawyer or an old lawyer. Just remember to try to talk to the judge and try to, you know, make sure you get your point across in a calm, cool way. And then I think it's just all the typical stuff. You want to be prepared. You want to expect the unexpected when you go to court. You know, there are things that happen that you don't expect. The judge might have a question about something that you did not expect. And so you don't want to stick with your brief then. You want to be able to answer the judge, and don't go off on your own tangent that you prepared. Make sure you can answer the judge. There's a lot of shooting from the hip there. I love that because I love to watch the lawyers do their thing. And in court, it's a lot more shooting from the hip than otherwise. So those are my tips. Irma?
Well, I agree with everything Judge Boyle said. And in particular, I think the most important thing is preparation. Prepare. Because that preparation is the bullets in your whatever, the thing with all the bullets that Rambo wore in the movie. Yes, the whatever. Yes. That's your preparation, all of those bullets. And you have to be prepared to know which bullet to use when. And I have seen very prepared young lawyers do much better than much more experienced lawyers, because the experienced lawyer was relying on experience and not so much the preparation for that particular hearing. So that is a way for a young lawyer to really shine, is with preparation. You can out-prepare somebody. Be clear and concise. It's especially important with oral advocacy. Think about when you're channel surfing. How long do you stay on one channel before you decide whether to move on? And I think there's lots of studies out there about the number of seconds. But we have attention spans just like you do. And if in court sometimes, in hearings, I've had hearings that went on a long time. So I didn't want to cut people off. I wanted to give them the chance to say whatever they needed to say. I think that sort of changed with COVID, because we're having to have more hearings by telephone or by video, or not having hearings. And so times become more limited just because the technology and things are moving more quickly. And so it's important to get to the point faster. Tell me what this is about clearly and concisely, because you don't have the luxury of all the time that you might have in a hearing that we've set aside for 1 hour. So you got to get to the point. Be direct. The most important point I can make for an attorney in a hearing, and especially a young attorney, is to answer the question. If the judge asks you a question, answer it. And then say, but I'd like to explain, or but. Because when an attorney pivots away, and I always know when an attorney pivots away, I know the answer is not good for the attorney. And you're already advocating, but in a way that you didn't intend to advocate, because you've told me it's not a good answer for you. Give me the answer. If I ask a question, it's because I really want to know the answer to that question. So answer my question and then give me the explanation or the spin on it. Because I'm always going to come back to my question. If you don't answer it, I'm going to keep asking it until you do. And it's just made you look like you don't want to answer the question because it's a bad answer for you.
And it probably always has to do with, number one, the elements of your proof for whatever it is you're before the court to do, whether it's sanctions, whether it's something else. You have to stick to your elements and look at what the court has to see to find for you.
And the being direct is important too, because in a hearing, you can see the judge's body language. You can see the expression. There are always going to be cues to you about when it's gone too long or when you're kind of rambling. In a phone conference, you don't have that. So you have to be proactive and really be short and direct and to the point, so that you don't get to the point where it's just too much information and you've lost your audience. Because once you've done that, you've stopped being an effective advocate.
And I wanted to follow up on this line of questioning before we move on to the next question about effective oral advocacy. Is there a virtual platform you have used or that you would recommend if, say, a litigant or an advocate wants to present exhibits? Anything that you found to be particularly effective? We had talked about earlier how the telephone conference can create a record. Is there anything that either has been effective or that is prohibited to use?
I have not used a hearing yet involving, evidentiary, like disputed pieces of evidence that people would offer into evidence. I mean, most of the evidence we have, everyone agrees on. So I haven't used that format for that. Have you, Irma? Judge
I have not.
So I guess we'll
Judge
Brown has.
Yes. I just had a lengthy hearing where there was evidence admitted, and we used it's like Zoom, but it's the federal court's version, and it's CMS. And at this moment, I can't tell you what that's an acronym for, but that's our version of Zoom. You do screen sharing, and so it required the parties to have their exhibits marked and on their laptop. So it's not like an Elmo where you could lay it in front of you and you had to have it on your desktop ready to upload and share. But it actually worked really well.
Was that on the website that you said you had problems with, Irma, or someone did have problems with it? Okay.
It is, and I've heard some people have great success with CMS. I think it's Cisco Meeting something. But some people it's worked really well, and I've heard people who've had great experiences with it, and then the next day they have a bad experience. So we're working through this. This is a brand new world for all of us.
But let's just hope we can go back to court pretty soon. I just hope so. That's
Absolutely.
what we all hope so.
Well, actually, Judge Boyle, if you could speak a little bit on that, is there any kind of hearing that merits an in-person proceeding under the shelter-in-place orders?
Well, you know, supposedly on the civil side, it is discretionary with the judge right now to have a hearing in their courtroom, but Judge Lynn has asked that we kind of don't right now, and everybody's going to be kind of upset about coming into court with masks. And so on the civil side, I don't know what that would be. On the criminal side, yes. I mean, we have sentencings. We've had lots of sentencing via video conference. Everyone has, and I think they're working all right, but I think everyone would like them in the courtroom. I think on May 1st, we're supposedly going to, I don't know, come out of this or go back to some of the—
Judge Boyle, I think you cut out for a second.
Can you hear me now? Can you hear me now? Can you hear me? Can you?
I can.
You just came back on.
Okay, I'm sorry. Yes, I mean, I just want to do the courtroom hearings, and I don't know what kind of hearing. I mean, like what Judge Brown just had. I think that was a hearing about all the jail inmates at Dallas County Jail, and she had people from all over, and that's a perfect example of where it would be better to have it in person, but she had it online. So I can't think of one where you'd have to have it in person, except in the criminal arena. Well, in the civil arena too, with jury trials. We have to have jury trials in person, I think. And I think we're all wondering how we're going to get these jurors to come down. I don't know right now. We've been suggesting things, and, you know, like talking to them online, and then striking them and having them come down with masks or something. I don't know about that. I know we're going to have to face that pretty soon, because the jury trials are stacking up. It's been 2 months now almost, and we have not had any jury trials. And so I think the jury trials are going to have to be in person, and we're going to have to address that sooner or later. Maybe someone can do an online jury trial, but I think it would be very, very difficult to do an online jury trial.
Yeah, agreed. And thank you all for those comments. Judge Rutherford and Judge Horan, have you seen any advocacy techniques that you thought were particularly effective for litigants who used a virtual platform?
Well, with respect to telephone conferences, I think it is very helpful for whoever is speaking to state their name before they launch into their argument. Again, that helps when we are creating the record, and it helps the judge. Sometimes people have very distinctive voices. Sometimes people can sound very similar when they're on opposite sides. And when you can't see where someone is seated or have the visual clue, it's very helpful to, even though it may seem to be redundant, I think it is actually very helpful to just say, this is Rebecca Rutherford, and my argument with respect to that question, Your Honor, is, and just sort of bookend it a little bit so that we know who is talking. The other thing I can say back to exhibits or PowerPoint slide decks, I always think that enhances an oral presentation. Before I was a lawyer, I was a teacher, and they taught us about different learning styles, and the human brain consumes information through all of the different inputs. So it's helpful to have a picture to go with the words. I think one of the things that, and it's not even particular to young attorneys, but sometimes attorneys can be over-reliant on their slide deck. If the judge wants to go out of order, sometimes that really takes them out of their game. They're not able to adjust. So you have to be very adept at maneuvering through your slide deck. It also helps to put page numbers on your slide deck so that, and I think this is helpful in the virtual world, so that if people are moving from one exhibit to the other, it's very easy for everyone to literally get on the same page, because the page is numbered 6. And so if you say, now I'm looking at page 6, it's easy for everyone to get on the same page.
You know, I agree with everything Judge Rutherford just said. And my number one tip with regard to telephone conferences or telephone oral argument, which I've had the entire time I've been on the bench, and in particular circumstances, is the advice that she gave, which is state your name. I mean, it may seem like it gets old, but it's not important for the judge and everyone else listening who may have trouble distinguishing between people's voices, particularly in the heat of the moment, which is exactly when you are most likely not to mention your name, even though you've been told to. But it's important for everybody to know who's actually talking. But it's also important for creating the record. And I guess I just pick up on that, both whether it's by Zoom or Cisco Meeting or any other platform we may be using, or by telephone. I think, again, even though it may seem sort of overly mechanical and maybe uncomfortable, the more you can really announce, to pick up on something Judge Rutherford was saying, not just your name, but, referring to Exhibit 5 again, or referring to this part of the appendix. I think it's important in real time, but it's also important because you're creating a record, and it's not quite the same as being in a courtroom with a court reporter sitting there. It's just not. And so to protect yourself going forward, a lot of things we may have by telephone hearing or oral argument may never go up on appeal, or even if you're in front of a magistrate judge, may never even go to a district judge for them to look at. But in some instances, we also just ourselves, if we're going to be writing an opinion afterward, need to go back and either get the transcript or go back to the recording. It's just important to have those place markers along the way so that there's no confusion about what somebody was talking about, and we can all keep up with exactly what part of the briefing or part of the appendix or what particular exhibit you're referring to, as well as who you are. So I guess my general advice would be, whether it's by telephone or one of these virtual video platforms, be aware of the limitations of it and how it's being recorded. And I think just the more explicit you are about things, even if it seems like a little paint by number at times, can only benefit you.
Wonderful. Well, as we come to a close for our presentation, for our last panelist question, I wanted to direct this to Judge Brown and Judge Ramirez. What is your court's approach to giving young lawyers additional speaking opportunities in the courtroom? And do you believe virtual hearings will provide young lawyers more opportunities to gain advocacy experience? And we could start with Judge Brown.
I absolutely think it's really critical for young lawyers to get some in-court opportunities. And so one way you can do that, if you have a motion that I would ordinarily decide on the papers, if when you file the motion and request oral argument, you'll make a notation in there that one of your young lawyers would like to present the argument, I would probably give you argument that I would not otherwise give you in order to give that lawyer an opportunity to come forward, get on their feet, and make an argument in federal court. Yeah. So you would need to notate that in the papers and request an oral argument. And if you'll say in there that this would provide an opportunity, I'll very seriously consider that.
Oh, I think that's a fantastic idea. I really do. And I have had some of those, not very many, but I really would encourage them.
I agree. Chief Judge Lynn has been a huge advocate for more court experience for young lawyers, as has Judge Boyle and Judge Brown. So I think most of the judges on the court are very much in favor of this. And it is important to let us know some way. I know that Judge Lynn's preference on this is on the website under her specific requirements. It's not necessarily there for all judges. I know I've not taken the time to do that, but if you file a motion, and I think it's important to do it separately. If you bury it at the very end, right before the prayer, I might miss it, because if I'm trying to go through something very quickly and get to the substance, I might not see that. So it should be in the title of the motion. You need to highlight it for us some way so that we don't miss it, because I think most of us want to give you those opportunities. Since we're not able to have court hearings and we're doing more electronically, whether by phone or video, there may be more hearings, there may be shorter hearings, but that could create an opportunity for young lawyers to have hearings, especially when it doesn't cost the client any money to fly the associate there. You don't have to have the partner. there are ways. Be advocates. Figure out how you can sell this to your
They ought to
customers
use
and
this
clients.
time to get in. I mean, you can sit back, or you can use this time for yourself to think of creative ways to get before the court. I think it's a very, very good idea.
Well, thank you, judges. I think we're coming to a close on the hour. And as we wrap up the panel discussion, I wanted to extend a sincere thank you to the judges, our panelists. The judges came here on really relatively short notice and prepared some excellent answers to our questions, and DAYL is extremely appreciative of your time. For those of you who need to leave, this is the official conclusion of our program. You can find the course number in the chat. Cherie Harris can put that in. But for our telephone listeners, the course number is 174-080-332. Again, that number is 174-080-332. The judges have kindly agreed to stay on for a bit longer to answer questions in the Q&A. So I can go ahead and start with the first question and let the panel weigh in. So the first question that we had was, it's a case-specific question, but one of the attorneys wanted to know what steps are necessary to attempt to confer with an unresponsive opposing counsel, and does the answer change for a pro se plaintiff? So we'll open that up to the panel.
Anybody?
I'll go. I think it's important to show the court that you have tried. I always, when I see a discovery motion in particular, I always flip back to the certificate of conference to see what efforts have been made before the motion was filed. And I think you have to be specific. I've called the opposing counsel several times. I've sent emails. And it's important to be reasonable. If you send your email after 6 o'clock on a Friday night, you might not get an answer before Monday morning or Sunday night when you file your motion. So, those kinds of things are important. Make sure that it's a meaningful attempt to conference. So give yourself time, give it several days. What if the attorney's on vacation? What if the attorney's out sick? What if the attorney's on leave? You don't know. So make sure that there's a meaningful effort to confer and give yourself time to do that. Does it change with a pro se? A little. I have seen so many filings by pro ses where they complained down to them, they were rude to them, they felt sort of taken advantage of because they didn't know the court system like the lawyers does. Going back to something that Judge Rutherford said, those communications, those emails often do end up as attachments to motions or responses by pro ses. I understand that it is difficult to litigate against someone who doesn't understand the system, but courtesy, it doesn't cost anything to be nice.
I mean, a generalized certificate of conference saying they weren't there, so here's my motion. That doesn't work ever. We look at that and we think, you haven't done anything to confer. So we want to hear specifically what you've done. And if it's a pro se, that you've sent them something via certified mail or something like that, because, we want to know that you've done everything that you can to talk to the other side, whatever that is.
I think what Judge Ramirez and Judge Boyle's comments underscore is that the attorneys have to be very proactive in managing their calendar, and as they're going through the course of the litigation, think about the timing. If you know your discovery period is coming to an end in 45 days and you have not gotten the discovery that you've been expecting from the pro se, you need to start building your record of reaching out to them. If you're relying on, if you need to have time to show that you've actually mailed them something, it doesn't do any good to put your letter to the pro se attorney or the pro se litigant in the mail on the same day that you file your motion, because the motion may have to be sent to them also once it's received by the court. You don't want them to be able to tell the court that they haven't heard from you or this is the first time they're hearing from you. So you have to be very proactive and think about how much time is left. Waiting till the end, especially in a case where the other side is a self-represented litigant, will really come back and reflect negative on you.
And the pro ses will lie to you sometimes. I mean, they will tell you that they have not heard anything, and so you have to have some objective proof that you've done everything you can to serve them, to get them to know what's going on.
Thank you. We actually have another question as well. And this question states that for compassionate release motions, if our clients get diagnosed with COVID or get additional complications after we initially file, should we consider refiling or amending our motions?
I say yes.
Absolutely. That's something important for the court to know. I would absolutely amend.
Because we are getting a lot of these motions. I know the magistrate judges have, and I have, because of appeals and just direct motions to me. And I think that we aren't going to let everybody go. That's just all there is to it. But there are some really worthy cases out there. And so you need to make your case as worthily as possible. And if you have more information, you better give it to us.
But it's important to put it in the context of the appropriate procedural framework. Just, oh, here's a new fact. Tell us why this new fact matters. And I think we've been able to put out a lot of case law relatively quickly in this district about the factors that we're looking at. And if your new information still doesn't meet what those factors have been discussed, then you know, you have to make a decision. But the framework, the procedural framework is very important.
Well, Judge Brown just did a big hearing on all this. Judge Brown, do you have anything to say about this?
Well, you know, the facts kept coming in as the hearing was going. And so every day, yeah, I just handled a jail lawsuit. I can't say too much because it's still in the hopper, but every day you would have different numbers of people who had the coronavirus. And so I would have to consider kind of new information as it came in. And so I would certainly encourage everyone who's dealing with people involved in this pandemic to keep the court updated because those changing numbers can certainly change things.
We have another question. This one is directed to Judge Boyle and Judge Brown. When it comes to sentencing memorandums, do you prefer that we track the 3553 factors, or does that get repetitive memo after memo?
Judge Brown?
I don't think that gets repetitive. Of course, now I am new to federal sentencing, so it's still it's not old to me at all yet. But it makes me think of when I would watch young lawyers as a trial judge when I was in state court trying to do a remix of the business records predicate, and they think that you're bored hearing the magic words, and it just, yeah, you have to do it that way. You know, if you do the Puff Daddy remix of the business records predicate, it's just not going to get in. You have to say open sesame. And I kind of feel the same way about federal sentencing. I think there are different ways to keep it interesting. The story that you tell about those factors, I think you can deviate from, and you can talk about people and their circumstances and make an interesting presentation. But as far as sticking to those elements and walking through them, I think you kind of have to do that. I appreciate that somebody wants to make it different and interesting. Judge Boyle, I defer to you because you've been doing this longer than I.
I've been doing it a long time, and I will tell you that the 3553 factors are critically important in sentencing because they make a difference as to what we do almost every time. So you want to have those in a brief, but you want to make sure they're not boilerplate. I mean, you want to make sure they're not just saying, well, respect for the law and, all this other stuff in just very general terms. You want to be specific, so specific about your defendant and why it makes a difference as to your defendant. And I like live witnesses to come in. So, I mean, I think it makes a difference when live witnesses come in, and at least it does to me. So I think the 3553 factors in the brief, along with some live witnesses, is very, very helpful in sentencing. It can be very helpful.
I have a question. Judge Brown, can you demonstrate the Puff Daddy remix of Business Records Foundation for us? I'd really like to see that.
Well, I tell you, I have seen it many times and it never works out well, where you just want to holler, just read it.
I received 2 questions that were submitted directly to the moderator, and these are questions that are open to the whole panel. The first question is, are court clerks working remotely? And is there anything young lawyers should know about the court staff to help them work more efficiently?
I
I'll
think they
jump
are.
in.
I think
Oh,
Go ahead. Go ahead. I'm not talking.
All my staff is working remotely, including my court reporter, who she gets the merit badge for Girl Scouts this week. She did a 5-day hearing remotely from her house. So my whole staff is working remotely, but they do have their laptops up and running from 9 to 5 and are taking calls, and calls from the court roll over to personal phones. And so we are still very much in business. We're just doing it remotely. I'm sorry, I stepped on other toes.
I think IT is down there. They have a skeleton crew. They're also at their houses. We're working remotely, but they're very, very much available. But they are down there. Some of them are down there. I don't know about the regular clerks. Does anybody know about that?
The clerk's office employees are working on shifts on a skeleton crew, so we have a limited number of people in the courthouse, and then we have the other staff is up and running at home. If you have a problem with CMECF or electronic case filing, there are definitely people available to help you live and in real time. You just have to go to the court website and use the telephone number or send an email to the help desk, because that assistance is definitely available to you.
And the court website is so helpful for so many things. Just go to it just to look at it if you haven't, or if you have it in depth, because there's so many drop-down menus of things that they have there that you wouldn't even know that they have. So be sure to look at that no matter what.
And the last question that I have that was submitted to me was, with respect to criminal proceedings, how are courts handling detention and revocation proceedings? Will these be handled virtually? And are courts delaying sentencing hearings or conducting them in court?
We are delaying a lot of sentencing hearings. Not all of them. Some of them have been done, especially in West Texas. They've done several. We have done them here remotely, but not near in the numbers that we normally do. And that's the same way for probation revocations and anything else that's having a hearing. Now, they've all been done remotely, but not nearly in the numbers that they are normally done. We are going to be backed up with our criminal cases in June, and I hope we can get back to work and do them all, and in May.
And as far as the initial proceedings in the criminal cases, in Dallas, we are still seeing people in person, but there are measures in place for social distancing and to help protect people. Prisoners are being brought in one at a time. There is some special seating over by the counsel table to allow for the 6-foot distance between the defense attorney and client. We've got the interpreter equipment for the client and attorney to use to be able to communicate with each other that way during a hearing quietly and without revealing attorney-client confidences. We're limiting the number of people who can be in the courtroom. We are live streaming those hearings actually down into the jury room on the first floor. So we really don't have an audience in the courtroom, although people can still go to the first floor jury room and listen to the proceedings. So we're doing the best that we can, but we're still going forward with some live hearings on the criminal side.
And they're doing, the magistrate judges, I want to say to all of them, are doing a wonderful job on the front lines for us, because, you know, we want to get back down there, but we can't. And, but what they have to, we have to worry about the marshal's safety and everyone else in the courtroom. And so I know they've had trouble with masks and all that in the courtroom, but they've had to do it, and they've done it in the courtroom. Otherwise, we are not doing criminal cases in the courtroom for right now.
Thank you, judges. I think that wraps up all the questions that I have received. If there's anything further the court judges like to share, you're welcome to share at this time. But other than that, that should conclude the whole of the program. So we thank you again, judges and attendees, for making this presentation a success, and we will now sign off.
Thank you so much.
Thank you.
Thank you all.
Thank you for
Enjoyed it.
doing this.
Thank you.
Bye.